Our goal today is to be sure that we are finished by no later than 3:30, so that anyone who is planning on or wishes to go to the Grotius Lecture, which is the opening event of the American Society of International Law annual meeting, in which Professor Amartya Sen will be speaking, will have time to get downtown. It's an event that is open to anybody participating here today, as well as anybody going to the ASIL conference over the next few days. So I'd like to invite everybody to the table. And I'll use the quiet for a second to just do a couple more commercials. In the packet of information that you have gotten while our panelists are settling in, Lori, is a brochure for a conference that we'll be holding here at American University on April 28th and 29th. On the Obama administration and human rights. The two-day conference is a high-profile, campus-wide initiative that the center is spearheading with the support of the president, the provost, and all 6 deans of the university. We anticipate high-level participation both from the administration, heads of all major human rights organizations in the United States as well as overseas, live webcasting to folks around the globe for those of you watching on webcast, and a very important discussion for 2 days of the current situation of this particular administration and its views towards human rights both domestically and internationally. So I would encourage you, if you are interested and able, to register early because we have very limited space, and we hope that you will all join us for that event as well. I think we have one more. Susanna is coming right back, and so, and there she is walking through the door. So with that, I'm going to turn the table over to my partner in crime, my partner in international humanitarian law, Colonel Dick Jackson, who is going to moderate this session. Thank you.
Thank you. Well, we have a great lineup of panelists today, and basically 2 themes that we're going to explore in international humanitarian law, and the first theme, and the one that that most of our panelists will address, is the confluence of international humanitarian law and human rights law. Where do they intersect? In what forms of conflict do they intersect? In what topics do they intersect? The foundation of human rights law and the foundation of the law of armed conflict come from the same place, and from that same 4-year period that Dave Crane talked about in the last hour. And you can see in the roots of both areas of law many of the same concepts. If you look at Common Article 3 to the Geneva Conventions, for example, and you look at the concept of procedures that are accepted by civilized people in criminal procedure, and then you look to Article 75 of Additional Protocol 1 that lays out those procedures, those due process procedures that are required for penal prosecutions as minimum standards to be applied in penal prosecutions in armed conflict. And then you compare that with the ICCPR, the International Covenant on Civil and Political Rights. You see that the roots of both concepts come from the same place. But the law of armed conflict and human rights law conflict on occasion too when they're coming together. So that's the first theme. Now, the second theme that I've asked the panelists to look at is the conflation of international armed conflict rules in non-international armed conflicts. Now, this also is an issue that really comes to the fore in the first discussion, the discussion about the confluence of IHL and human rights law, because A non-international armed conflict, normally, usually, generally, is conducted in a state party to the conventions. So what little law is provided in IHL to apply is really supplemental to the domestic law of that state. But if you don't have the domestic law of the state available to you, or your own domestic law, then a trend that's been developing is bringing international armed conflict standards into non-international armed conflict. Now, why is this? For a country like the United States that says it does not apply extraterritorially its human rights law, the treaties that it has signed are not generally applied extraterritorially. There's a vacuum as to what law to apply in a non-international armed conflict. Common Article 3 leaves you with not much. We're not signatories yet to Additional Protocol 2, although last week the President announced that he was sending Additional Protocol 2 to the Senate for ratification. So what law do you apply? If you're a lawyer, you know, as many of us have been on the battlefield, you're looking for what law to apply. And so you either have human rights law or you have the law of armed conflict. And so this other trend to fill that vacuum is a conflation of international armed conflict laws into non-international armed conflict. Or another way of looking at this is applying law by analogy, international armed conflict laws to and non-international or internal armed conflict. So we've developed a series of questions that are intended to explore these topics, and we've got a great lineup of folks to do it. Jamie Williamson on my left is the Regional Legal Advisor to the International Committee of the Red Cross, and has a great deal of experience not only with the ICRC but in the international criminal law field, and will add a lot to this conversation. To my left, and not on your expert roundtable program, but certainly an invited member of this panel and a key member of it, is Lori Blank, who teaches international humanitarian law at and heads the IHL clinic at Emory University. Has been very instrumental in the teaching of IHL project writ large across the country, and is also an executive committee member of the Libre Society. On my far right is Susanna, who is a professor here at WCL, and has a great deal of experience from the international criminal law perspective, but heads the War Crime Research Office here at Washington College of Law at American University. And you've already met Gary, so I won't go any further. And as I said, his bio's in the program. And finally, Professor Rick Wilson heads the International Human Rights Law Clinic here at American University, Washington College of Law. So let's start with our application of human rights law in extraterritorial, non-international armed conflict. The first question is to Professor Solis. In a scenario where State X armed forces are assisting State Y armed forces to suppress an insurrection within a state, within State Y, are State X armed forces subject to international human rights law? And if so, which law? The law applicable to X or the law applicable to Y? Can he give some examples of rights like the right to life, the right to liberty, the right to habeas corpus? And then, of course, I've also asked Gary to look at this IAC-NIAC conflation issue. Gary?
This is a hell of a question. I tell my students in the first class every semester that you're going to leave this room with more questions than you have coming in. And I think you will find that there is not entire disagreement even among the panel, let alone experts around the world. Well, first of all, you have country X assisting country Y against insurrectionists within country Y. So we recognize first that this is not an internationalized armed conflict. X is assisting Y. It's much like, well, it's not an internationalized conflict. It's still a common Article 3 armed conflict. Now, what law applies to whom? It depends on whom is. It depends on your definition of, etc. As you know, the United States and Israel take a different view of the application of human rights law on the battlefield. To the bulk of the world, to most of the world, the law of armed conflict, LOAC or IHL, and human rights law coexist on the battlefield. It's U.S. policy, however, that the lex specialis remains the law of armed conflict. Human rights law does not apply on the battlefield. Now, that's our position. And yet we see an ever-enlarging wave of human rights law being enveloped in our current common Article 3 armed conflicts in Iraq and Afghanistan. We say, no, no, no. Human rights law, not for us. And yet we are training our officers to initiate chains of custody, to take sworn statements, to take photographs of the accused next to the evidence, all of which are human rights issues. These are not law of war issues. I didn't get any of that when I went through the basic school as a second lieutenant, but today at Camp Pendleton, actually it was 2 months ago, at Camp Pendleton, 30 Marine officers were sent to the Los Angeles Police Department for 30 days of additional duty to see how the police officers conducted their investigations. Now, you must appreciate, of course, that Marine officers are trained not in human rights law, but in LOAC. Police officers are trained not in LOAC, but in human rights law. The decision to employ deadly force is critically different in human rights law and in LOAC. So, country Y is facing insurrectionists. What law applies there? Common Article 3. Country X comes to the assistance of country Y in their fight against their insurrectionist. It remains a common Article 3 armed conflict. If it's the United States that's coming to the assistance of country X, then we will say, no, no, no. But in fact, we are seeing, it's an inexorable tide, in my view, an influx of human rights law on the battlefield, on American battlefields. Now, I realize I digress a bit from the basic question, but we see this, for example, we see it, of course, in 1977 Additional Protocol Article 44.4, where it says, even if you don't meet the criteria for POW status, you will be given a status exactly the same as POW status. In other words, we're seeing some human rights come into the battlefield in Article 44.4. 44.4 being one of the primary reasons the United States has not yet ratified AP1. But we see it in other ways as well. And I've already mentioned some of them. So I think it is clear, and of course, when you have the armed forces essentially enforcing or engaging in what are usually law enforcement actions, Professor Crane was talking about terrorists being criminals, then you again see human rights law making its entrance onto the battlefield. So if the country X that's coming to the support of country Y is the United States, we would say no, but in fact there's going to be a large human rights law aspect to the assistance, although we would say otherwise right now.
Gary, if country X and Y are eminent in the United States, and we're talking sorry. If country X and Y are Yemen and the United States, and we're talking about the United States coming to the, just assume there's a non-international armed conflict in Yemen. I won't get into that point for the purpose of this discussion. And the U.S. is coming to the aid of Yemen in that non-international armed conflict, and spots an enemy both of Yemen and the United States named al-Awlaki, and decides to target him. Are we applying a human rights right to life standard, or are we applying a non-international armed conflict targeting standard to that individual?
In my opinion, the latter. We are targeting a NIAC, we are applying a NIAC targeting standard. If an individual is an enemy fighter, I don't want to use the term combatant because that has other implications, as you know, in the law of armed conflict. If the individual is an enemy fighter being determined by his actions or her actions, then he is a legitimate target. Citizenship in the al-Awlaki case is a red herring. Citizenship has absolutely no bearing on targeting. As you know, in World War II, we had Japanese, we had Germans who went back to their native states to fight with their native armies. We didn't ask, well, what's your citizenship? We killed them if we could target them. So if al-Awlaki is an enemy fighter, and I'm not yet convinced that he is, but if he is a legitimate target, and he may be killed under the law of armed conflict. Was that all of that question? Yeah,
let's change it around a little bit too and address the current conflict in Libya. Okay, if it's a say it's a non-international armed conflict, and in this case we're coming in on the side of the insurgents against country Y. Would it change your answer as to what standards you apply?
I have two test questions now. Clearly, the law of armed conflict applies to U.S. combatants. And as some of you may know, particularly those of you who may have served in the armed forces, the United States years ago has said that no matter what the conflict status is, CA2, CA3, we, the U.S., are going to apply the law of armed conflict in its entirety. So if we are going into Libya on the side of the insurgents, the law of armed conflict applies to American forces. What law applies to the insurgents? The law of Common Article 3. The insurgents are indeed bound by CA3, despite the fact that they have not signed or ratified any part of the Geneva Conventions, and indeed could not. Now, I'm assuming that the insurgents have an organization and a leadership sufficient to make them an armed opposition group. If they are merely a band of fighters with no organization and no leadership, which is not inconceivable in this case, then you have an even more difficult question. In that case, one certainly, at a minimum, the domestic law of Libya applies to them.
General Carter Ham, who is the commander of the U.S. forces, was on the radio yesterday, and he said that the fighters in Libya on the insurgent side are civilians, and mixing a little bit of Usad Bellum and Usin Bello here, he said we're charged with protecting civilians, so we're protecting those fighters. Would you look at that issue, and is General Ham right in calling them civilians in this non-international armed conflict, internal armed conflict in Libya? From the perspective of the forces, the coalition forces, and from the perspective of the Libyan armed forces, are these guys civilians?
In my considered view, considered for about 10 seconds now, in neither case are they civilians. They are objectively fighters. They have weapons. They are fighting. Ipso facto and ergo, they are not civilians. They are civilians who have taken up arms and are taking a direct part in hostilities. So, which of course is the classic definition of unlawful combatants. But they are fighters. So what law applies to them? Domestic law of Libya, Common Article 3. The law that applies to the United States is the law of armed conflict in its entirety by national fiat. Were it not for that DOD order, the law that would apply to U.S. forces would be Common Article 3 clearly, and the U.S. would say not human rights law. If a nation other than the U.S. were coming to the aid of the Libyan fighters, then clearly Common Article 3 would apply, as well as human rights law. Now, does this suggest that there may be different legal regimes applicable to different fighting groups on the same battlefield? Apparently so. Apparently so. A very unusual circumstance, needless to say. Now, examples of some of the rights include right to life, right to liberty, and right to habeas corpus. Well, some rights constitute customary international law. And individuals obviously may not be killed out of hand. There is a certain right to life, which I recognize as a human rights issue. There is a right to liberty, also a human rights issue. And so not even a combatant in U.S. forces may kill someone out of hand. Now, the right to habeas corpus, I mean, you can't even get the D.C. Circuit Court to agree on that one. I don't think we're going to agree here. But I don't think the right to habeas corpus is a right that you're going to find on many, a right you're going to find applied on many battlefields.
Gary, we're going to get into that for a second. So let me interrupt and go really to the next topic. But I want to wrap up with this first topic. And what you've seen Gary do is apply the concept of lex specialis. Now, there's debate within the community about whether lex specialis is an interpretive canon or a choice of law question. I mean, the way Gary stated it was essentially an interpretive canon because he said there's a right to life and the right and that right exists even in armed conflict, which is I guess the mainstream view in the international humanitarian law community. But then he applied the lex specialis of armed conflict to determine whether or not the means employed to take the life of the combatant was proper, was lawful. Okay, so, but that's let me move on to habeas, and you'll get a chance to respond. Okay, a two-finger. Well, of course.
I went. I was at Roundtable yesterday, and then we used this two-finger thing. So quite funny. It works. Actually, no. Mine was simply a question. Maybe we can hold on to that for the group discussion later on. You raised the Libya question, and we talked here about a non-international armed conflict situation initially. I was wondering, and I know Additional Protocol 1 is of not much relevance to the U.S. Because it hasn't ratified it. But if we look at the qualification nature in AP1 in terms of people's right to self-determination, and the fact that there are reservations inserted there in that if you recognize those peoples, then ultimately you create an international armed conflict. Were the statements of the French and others in recognizing the rebels as a legitimate diplomatic entity sufficient in your mind to create an AP1 style conflict?
Yeah, that's a really good question, and one that I think you'll get different answers from the different parts of the coalition on, because if you look at the reservations, declarations, and understandings filed with the ratification of AP1, many states confine that portion, Article 1.4 of AP1, only to the specific terms of its provision, and it deals with nations that are struggling under to throw off colonial domination or alien invasion, or the apartheid situation. I can't remember the exact term for that. And so many of those nations, and I think that includes the UK and France, would say that self-determination is not what 1.4 is talking about, except when it's self-determination from colonial rule or from alien occupation. So yes, it might convert it to a AP1 conflict, but I don't think the French but that maybe the recognition would change it to belligerency, which is the equivalent of an international armed conflict, when you have two nation states, essentially, that are fighting. So that's another aspect of this. Gary, you want to get into it?
What vitality does the concept of belligerency continue to have, do you think, Dick? I think it's certainly diminished if it's not expired.
Yeah, well, that's a question of whether or not the UN Charter regime and this idea of territorial sovereignty being paramount is wins out in the argument, and that's a jus ad bellum question that I think we can we'll have to move on from. But let's move on to question 2, which takes on which focuses on one piece of this debate, and that is say that state X in assisting state Y seizes an individual, detains an individual. We've talked about targeting and the right to life. That one of the areas where the confluence of these two bodies of law is most pronounced, and we've seen this played out day in and day out, and in Professor Wilson's life on a daily basis, in the removal of detainees from the battlefield in Afghanistan and placing them in Guantanamo. So does human rights law apply extraterritorially when a combatant is taken outside the conflict zone to a third country, is the question for Professor Wilson.
I love the debate between these two guys on either side of me who are bandying about the terms of belligerent, combatant, fighter, not a term of art, but one that I think serves for the occasion. And then this debate also about who's a civilian and who isn't. Because I wouldn't profess ever to hold myself out as an expert in international humanitarian law. My expertise is in international human rights law, and what international humanitarian law I have learned from my representation of detainees at Guantanamo Bay. And I'm delighted to hear that it's as confusing as I thought it was with regard to sorting out these categories, because what you call the individual in the particular circumstances, I think, is one of those definitional steps that has all kinds of consequences downstream with regard to the application of the law. So the question itself, when you take a combatant outside of the conflict zone to a third country, begs the question as to whether or not the obvious situation that we have in Guantanamo includes combatants. Are the folks being held at Guantanamo Bay combatants? There is a determination which has been made along the way that they are, in fact, combatants. I think all of those who are held there have gone through that process and have been determined to be combatants. Some we are now saying may be subject to indefinite detention, potentially being held there forever. As a litigator, one of the things I think that most surprised me about this, the engagement of this issue in the U.S. courts through the habeas corpus battles that have gone on in the D.C. courts and in the D.C. Circuit is the extent to which the focus has stayed almost entirely on U.S. law to the almost complete exclusion of international human rights law. So all of the work that I've done and all of the work that I injected into briefs along the way to say, here's an international human rights concept that applies in this situation, almost always got shelved, avoided, moved to the back, taken out of the brief by co-counsel because it wasn't focused on enough on domestic law, where the battle we felt the battle was being fought, and maybe for good reason, because of the way that the U.S. courts treat either treaty law under international human rights law or custom in international human rights law. But I want to hearken back to actually an incident before we ended up in the courts in the United States and look at the situation in the Inter-American Human Rights Commission, where I was one of the counsel for the then unnamed detainees at Guantanamo Bay, on whose behalf we sought what are called precautionary measures from the Inter-American Commission on Human Rights early in 2002, just after the facility was opened. And as early as May of that year, the Inter-American Commission on Human Rights, in what I think it was a sort of prescient decision in the sense that it anticipated decisions that came later from domestic courts in the United States, found that the individuals held at Guantanamo Bay were susceptible to jurisdiction in the United States because of the provision that Colonel Jackson referred to in the International Covenant on Civil and Political Rights and similar language in the American Convention on Human Rights that talks about when parties are susceptible to, when states are subject to jurisdiction of the individuals who are, and I'm quoting now from the ICCPR, within its territory and subject to its jurisdiction. In that case, and in many others, there and in the European Court of Human Rights, the Commission and the courts have found that one is subject to the jurisdiction of the state holding them if they are within the effective control or within or subject to the state's authority and control. That's the test that is used. And the Commission found that Guantanamo is exactly such a situation. They said it has nothing to do with nationality, as Gary said, nothing to do with citizenship, but even within a particular area, but whether that person falls within the state's authority and control. The difficulty with that decision, I think, has been the way that it has been extended or attempted to be extended in subsequent litigation, because there is, I think, certainly after the Boumediene decision, now a number of cases, some 40-plus decisions by the courts, some divided, but I think a great number that have been favorable to the detainees that have decided their habeas cases on the merits favorably to them. Many of those, all of those cases are on appeal, but two of the most interesting are cases that had to do with the extension of jurisdiction to Bagram Air Force Base in Afghanistan. And in that situation, the Judge John Bates, who was the judge in the case that I had for many years there at Guantanamo Bay, a case involving Omar Khadr, the young Canadian who recently pled guilty in a military commission. And we have our opposing counsel in the audience today, at least at the time. And Judge Bates reached this issue about Bagram, found it to be analogous, at least in some ways, to the Boumediene rationale, and said it would be extended particularly to those individuals who were not captured on the battlefield in Afghanistan, but who were moved to Bagram for reasons that the U.S. military forces chose to put them at Bagram. That decision didn't survive on appeal. The case is Al-Makale versus Gates. And in May of last year, the D.C. Court of Appeals reversed. Mostly, I think it can fairly be said, on grounds that this was an area of active combat and that in normal circumstances, habeas would not extend to that particular context. I think that's a fair statement. But even the Court of Appeals, which I think, as Gary's already noted, has been notoriously conservative on these issues about the reach of habeas, despite the admonitions from the Supreme Court on several occasions. They've been very, very conservative about it, I would say, as a group. The Court of Appeals found in Al-Makale that if there could be a demonstration that the administration had somehow manipulated, was the term I think they used, manipulated the situation to place prisoners there to intentionally avoid jurisdiction in a place like Guantanamo, if evidence could be offered to that effect, they might find that habeas would reach even to Bagram. So the latest development in that case happened last month, and Judge Bates, on remand, found that he would accept new evidence. He didn't say what. All this stuff is classified. But he found that he would accept new evidence, which I assume would show some indication of manipulation. Otherwise, I doubt if he would have allowed it. This was in February of this year, so it's very recent, that said he would allow the petitioners in these several Bagram cases to amend their complaints, and then he would entertain, in fact, he invited a motion to dismiss on jurisdictional grounds from the respondents, the government of the United States. So I think this situation is still unfolding in the habeas context, and I suppose I would stop there with just an indication that, as Gary said, there are not only guarantees with regard to human rights law that apply to the reach of habeas corpus, but several other guarantees. And I think the one certainly many of us were most concerned about was the one that had to do with the use of torture or cruel, inhuman, or degrading treatment during interrogation. And those issues have, I would say, virtually disappeared from the playing field in the habeas context, at least, and have not been adjudicated or reached in the context of these cases. Almost all of the, if I'm not mistaken, and I haven't studied these extremely closely, but for a few cases, notorious cases at military commissions, like the one that was not pursued because of the interrogation practices, the use of evidence obtained under torture has not come into play. And in fact, we did litigate that issue with regard to young Omar, who was held during a period of time when he was 17, 18 years old and interrogated vigorously. We argued in such a way as to constitute torture, and Judge Bates found in that situation that we were not entitled to relief, prospective relief, to enjoin future interrogations of Omar at Guantanamo. So those are the kinds of issues that get litigated, and I think have an incredible uphill battle in the federal courts. So the theory, the difference between the theory, the way the international law is articulated, and the way it gets practiced, certainly in the U.S. courts, both because of this general exceptionalism and I think the way that U.S. courts treat treaties has resulted in a great deal of difficulty in getting international human rights law to be applied as a body of law in the U.S. courts.
Thank you, Professor Wilson. The ICCPR issue, or the application of human rights law, kind of turns on a strange issue of and or. The ICCPR says that a person in the territory or under the control of a state, we apply the ICCPR. But in contrast, the European Convention on Human Rights says, no, I'm sorry, it's the other way around. It's and, which means if it's neither, then it doesn't apply. But in the European Convention on Human Rights, it's or. So there's some jurisprudence out of European court that says that these habeas rules apply even on the battlefield, or at least some form of review of detention. I'd like to take a slight segue from this issue and ask Lori, that are there other human rights concepts that should be applied to individuals being taken from back to country X from country Y? And this gets us back to the panel we were on a couple of weeks ago, and the question of the executive order that just came out on the 7th of March that said that a law of war detention model would be applied to those remaining at Guantanamo for their periodic review. Lori, do you believe there are additional human rights-based rights that should be applied to the review of detention of the individuals at Guantanamo? And then, after you answer that question, would you look at the question we talked about, which is, when in a non-international armed conflict, should a state use law enforcement versus military operations?
Well, thank you very much first for including me in this panel. In terms of the specific question regarding additional rights for folks in the situation that you mentioned at Guantanamo, where they're calling it law of war detention, I think in that specific situation, I think there should be additional rights beyond what there would be in LOAC, primarily because, as we talked about at the panel last month and as I've written about, I'm not convinced that law of war detention is a reasonable label there. And so in a situation where there's a clear blurring of whether or not we are talking about purely law of war detention versus detention that maybe crosses some boundaries into outside of law of war, more of a law enforcement type of detention, then I think we need to incorporate additional rights. Certainly as a matter of policy, whether or not specifically in response to identifiable legal provisions, you know, you have to get into the nitty-gritty of that, but as a baseline, as a matter of policy, it just makes sense to ensure that there are sufficient protections when we are talking about an amorphous area. And we're not exactly, we're trying to take one legal framework and impose it on something where it's not clear it quite fits, you know, like a sheet that's a little too small for the mattress and you're trying to stretch it over all the corners. Last time I used square peg in a round hole, so that was good. But it's not as good as post-decision now. But onto the larger question of when human rights or law enforcement standards would be appropriate in a NIAC. Sorry, this is very high. I think what I'd like to do is think about as a framework for how we could think about this, and probably pose more questions maybe than find answers. But the first premise goes back to what you were talking about in terms of, are we looking at this sort of as choice of law, legal interpretation? We know we're in an IAC here, so we already know that the law of war applies in some way. So we're not necessarily talking about just from the question. There are other questions where we might say, are we in an IAC? In which case, which kind of law, if we have uncertainty about the characterization? It's a separate question that I'll get to. But I think when we're looking at the law, you know, law of war versus human rights law enforcement, I think we need to first look at where do we see coalescence between the fundamental guarantees in Common Article 3, AP1, and the portions of AP1 that are customary law or reasonably accepted to be customary law. Where do those mirror human rights guarantees, and where do we see a departure? And here I'm going to borrow from my good friend Jeff Korn, who framed this very nicely in an article that came out last year, where he talks about a distinction between pre-submission and post-submission operations. And if we look at the areas where we see a lot of agreement, we see treatment, trial, detention raises, a lot of similar questions. Those are all when we're talking about people who are essentially no longer the enemy. I mean, they're still maybe from the enemy, but we have them in our control. They're not shooting at us at that moment. And the other area where we don't see so much agreement between human rights and LOAC norms would be use of force and targeting. And here we're talking about pre-submission or operational considerations. And there, I think we have to look differently at how we would maybe borrow from one to the other, if that's the right term, or look at them in a complementary way. And people often talk about human rights law being a gap filler during NIAC or situations of uncertainty. And I think that makes a lot of sense. But what's interesting is you can look at this from two sides. And then we see that, unfortunately, we don't get a very good answer, because one starting point is you often hear the statement, well, in NIAC, we don't have a lot of treaty rules. We don't have a lot of positive codified treaty rules in the LOAC applicable in a non-international armed conflict. So that brings up a great opportunity to fill gaps with human rights law. By the same token, at the same time, we have international jurisprudence of tribunals and other bodies steadily applying the rules of international armed conflict in a non-international armed conflict. So we're kind of coming at it from two angles, and this brings in your question about the convergence. Also, we almost see a huge convergence from two or three different directions where we're trying to, in essence, it's almost like we're creating a body of fundamental guarantees that apply sort of along a continuum, if you will. So I want to highlight more the area of use of force and targeting here, because I think there is a greater agreement that the fundamental guarantees in Article 75 of AP1 are fairly close to human rights law. And Common Article 3 is often considered a human rights treaty in miniature. We don't have a lot of discomfort with that in terms of how we can look at human rights law in those situations. But there was a question posed in something that I was reading that kind of raises some of these questions about when do you use law enforcement and when do you use LOAC standards. And the example was this: if you're looking, say, in Colombia, if a member of the FARC is, shopping in the mall, can the government target him with deadly force as a first resort, while he's buying, I don't know, juice or whatever it is? And that's a kind of a tough question, because if you look at it solely from a strict law of war perspective, you would say, well, he's an enemy fighter, to use the term you use, and it's in the manual on non-international armed conflicts. So he would be a legitimate target at all times. He's not a civilian participating in hostilities, a member of an armed opposition group. Okay, but if we think about this maybe in the context, that's a bit of a frightening thought, is there's lots of ordinary folks who are just going and buying juice right next to him, or milk or whatever, and now we're talking about a situation where civilians are in danger. So how do we figure this kind of question out? And we can look at the distinctions. We all know human rights, deadly force is a last resort, law of war, it's a first resort. The whole conception of proportionality is totally different in terms of who it protects. In law of war, it's protecting the unintended victim. In human rights law enforcement, it's protecting the actual target of the force. And so a lot of people will talk about, well, let's look at a continuum, in essence. If we're in a NIAC and the government has great control over the area, effective control, to use a very, a term used in the jurisprudence, then we should use human rights and law enforcement standards. If it's an area of ongoing combat where there's not really control by one side or the other, we should use law of war standards. That makes sense sitting here, sitting on the airplane this morning when I was thinking about this on my way up here. But if you put yourselves in the shoes or boots of the soldier on the ground, I think that creates a lot of operational ambiguity. And I don't think it may be somewhat effective after the fact in trying to analyze what happens in a particular situation. But and there are a lot of people here who actually have been in the military, and so I don't presume to speak for you, but I think certainty is a very critical feature of operations. Understanding what your rules of engagement are, what the parameters are, what the law allows you to do or doesn't allow you to do. And if it's a continuum kind of thing, to me, that creates ambiguity on the ground. And so I guess this is going to be the question-raising portion of what I'm talking about as opposed to the answer-finding portion of it. But I'd like to throw that out to the other panelists and to everybody here, does the existence of ambiguity, because you don't want to have rules of engagement that say, well, when you're in an area where we have a lot of control, then take your evidence, take your photographs, arrest the person. And now when you cross that line into the next neighborhood, gosh, we don't have so much control there, now you can shoot in first resort. That is very ambiguous.
Lori,
So-
can I throw this back at you? Would you say that this approach is required as a matter of law, as this continuum approach, as a matter of law, kind of like Chapter 9 of the DPH interpretive guidance suggests, or would you say as a matter of this is good policy to take this approach? In Iraq, for example, kind of following on Gary's example of preparing for evidence, they shifted from preparing target folders to something they called warrant-based targeting, which and it was a creature of the security agreement, which said that in order to detain somebody in the conflict after the transfer to real Iraqi control, you had to have a warrant in order to detain them. So that's what drove, at least in Iraq, this approach of evidentiary procedures of preparing enough evidence, not intelligence. Intelligence drives targeting, but evidence to get a warrant in order to go and arrest the person. So, is it a matter of law or policy? And is that approach, that transition that I've described, a manifestation of the kind of approach that you've suggested?
I think it is a manifestation. I think this idea of sort of transitioning from one to the other should not be a matter of law. I think right there you're setting the foundation for ambiguity. I think it's being used as a legal interpretive device, which may be useful. I think as a matter of law, for the purpose of effective operations, we need to have a lex specialis, a determined identifiable framework that governs, and then, as a matter of policy, incorporate as many norms that are effective to help guarantee the most protections for people, and especially that's why this, I think, distinction between active operations and treatment, trial, detention, post-capture situations makes a lot of sense, because it's much easier to weave in more norms, more human rights principles, additional legal frameworks at that time when the decision-making process is not a split-second decision-making process. The other, just to sort of raise maybe a devil's advocate point about the use, trying to promote the use of law enforcement standards in NIAC, and I don't say this is determinative one way or the other, but I just want to throw it out there, is if you think about the purpose of the development of law of war over the last century, pre-Common Article 3, internal armed conflicts were generally sort of secluded from international attention. The whole idea was that the state thought this was their bailiwick, and these are insurgents, rebels, whatever you want to call them, domestic criminals. We get to do what we want, international community. You don't have a window into what we're doing. Common Article 3 was revolutionary, as we know, because it focused international attention and it began to inject international norms into an internal armed conflict. It seems to me that you start to say law enforcement principles and norms should be the dominant force in a NIAC, you're almost undoing that in a way. Because a state is going to want to say, this is a domestic issue. We're handling this as a law enforcement matter. There are no relevant international norms that we have to abide by. I'm not saying this would happen all the time. It's sort of one of these perverse devil's advocate arguments. But I throw it out there as a danger that can come from saying, well, it seems protective to say human rights and law enforcement is a much better way to go about things in a NIAC. But I sort of want to suggest, and maybe in a, like I said, a devil's advocate way, that it actually could have dangers in the reverse direction.
Thanks, Lori. And Lori has essentially described the continuum or application of law in counterinsurgency that's recognized in the Department of Defense Army Marine counterinsurgency manual. But there's another consideration here, particularly when we're talking about the confluence of these two sets of law in a non-international armed conflict within the country that the non-international armed conflict's going on. And that is that the end result of warfare is a return to normalcy. And that at some point in time, the conflict has to end. And one thing that makes that happen quicker is the imposition of the rule of law and domestic legal standards within that nation. So, for example, in advising folks about detention procedures in Afghanistan and the detention review panels in Afghanistan, what we've advised is that we should make those procedures look as much like a domestic detention regime would look like, including review by judges, including rights to counsel, et cetera, as a bridge to the Afghans doing it themselves. I mean, that's the raison d'etre for the military forces is to conclude the conflict, to get out of there. And the only way to do that is to put a mark on the wall that really shows a transition from law of armed conflict standards to human rights standards. Okay, let's move on to the next question. It's actually two questions for Professor Sakoto. And the first is regarding a private contractor, a mechanic or an interpreter stationed in a conflict zone to assist the armed forces who commits human rights abuses. For example, a rape of a local woman. It's outside the scope of his or her duties. How does IHL and human rights law interact to bring justice to the victims? And second, returning to this idea about differences between regional human rights bodies and how they apply this confluence, are there different approaches between regional human rights bodies in the application of IHL? And are there intrinsic differences in the regional systems to explain these differences? We've given these two difficult questions to a human rights attorney that I'm sure is capable of dealing with them.
Well, Steve, I should say, since I've been running the War Crimes Research Office for 6 or 7 years, my focus has been on international criminal law or criminal accountability for serious human rights violations or serious violations of international humanitarian law, which is sort of a limited world in terms of this discussion because, as you know, not every violation of international humanitarian law or LOAC gives rise to criminal responsibility at the international level. So it's sort of a limited world of norms, the breach of which trigger criminal responsibility. But the first question, let me go to the first question and try to take each in turn. I think the first question is in large part a question of accountability, right? Is there accountability for private contractors who commit abuses, human rights abuses, outside of the scope of their duties in a combat zone? And I think the question largely depends on whether we're seeking to hold the state or the individual accountable for the abuse, right? So I'll say a few words first about holding the state accountable and then perhaps look at criminal accountability for the individual. And I think I'll start with the state because we still operate, as this discussion reveals, very much in a state-centric focus of international law, right? And so I think that we should first consider whether the conduct of a private contractor invokes the responsibility of the state. Now, there's sort of generally two requirements for a state to be held responsible for conduct of a non-state actor, like a private contractor. One is that the conduct must be a violation of international norm, and two, that the conduct must be attributable to the state. And that one is actually a pretty simple one with respect to the first question, right? Are these abuses a violation of international humanitarian law? Now, we'll make a couple of assumptions that we've talked about, right? As an initial matter, the application of IHL depends on certain thresholds
How about a kind of a bastardization of the command responsibility approach of known or should have known, a widespread pattern of human rights abuses that the state failed to deal with?
I think that's absolutely the third concept that I think would be relevant is the due diligence, right? The absence of the state to take reasonably available measures to prevent, investigate, punish, and maybe redress the harms by a non-state actor. And it's been regularly applied, this due diligence standard, by human rights bodies, including American and European systems. But, you know, the question again, so there could be an argument that if the state which hired the contractor failed to do those things, failed to investigate and punish, that this may invoke state responsibility. But of course, this gets us back to one of the questions we had before, which is it may be only if those obligations are deemed to apply extraterritorially to the conflict. And that's a separate question. So I would just suggest, I mean, there's a lot more to say about state responsibility, but I would say that international law violations by private contractors, attributing that to states is not an easy task. It's not an easy road. And even if one is able to make a persuasive argument to that effect, there's also the difficult problem of enforcement. Where would one enforce that kind of case? There are limited mechanisms to hold states accountable for violations by private contractors. So you could, for instance, one option, for instance, is a complaint by the state of which the victim is a national against the state which held a private contractor, which hired a private contractor, before a human rights committee or the human rights committee or another human rights body. But again, state-to-state complaints are very rare for political and other reasons. I think you have the same issue before the International Court of Justice. You could also have a state take another state before the International Court of Justice. But again, political, economic, and other dependencies of the victim state on the perpetrator state often make it unlikely that a state will sue another state for these kinds of violations. So then what are the options are limited, I would suggest. And I think it takes us into the question of the options for holding an individual accountable for the abuse. And one option is, of course, prosecution at the international level for crimes against humanity or war crimes before, say, the ICC, the International Criminal Court. But again, for the reasons I'm going to lay out, I think this is also hard and unlikely. Right? First, there's some sort of admissibility and jurisdiction questions that have to be met. The abuse has to have occurred on the territory of the state party or committed by a national of a state party to the ICC. If it's not referred to the court by the security council, the Libya case or the Darfur case, but unlikely to be the case in this scenario, right? Or at least we don't have facts suggesting that. Second, we have the principle of complementarity at work at the court, which means that the court will only step in if a state with jurisdiction is unable or unwilling to prosecute the contractor. Not sure what the scenario is here, but let's assume that's not happened. The third, and I think third and fourth are the most difficult aspects here, hurdles, is that the ICC is very unlikely to reach these cases. It's focused on those most responsible for the crimes within its jurisdiction, and it's unlikely that a private contractor employee will fall into this category. And indeed, there has some, and there's little history to the court yet, right? We're only 7 years into this. But to date, there have been no prosecution of private contract employees by the ICC. Even, say, all these hurdles were cleared, even if that were the case, the definition of crimes within the jurisdiction of the court itself would make it difficult to prosecute those cases. Right?
And of course, we have the Military Extraterritorial Jurisdiction Act, which is a means of extending our domestic criminal law overseas. But this is an important point in conflicts. It's really and something that we encounter, particularly working with other nations in UN operations, where the nations have not extended their own domestic criminal law to cover the forces that they're projecting. I mean, this is a just terrible problem in the Congo right now, and the Secretary General keeps emphasizing this point. When a nation stands up to work in a peacekeeping operation, they ought to make sure they've got a means of disciplining their forces. Of course, it's an obligation under the law of armed conflict to be able to do it, and it should include civilians that are accompanying the force.
Rhodesia extended military jurisdiction to DoD contractors, but also to those supporting DoD missions. So we had at least that capacity under Rhodesia, and there have been some cases where contractors have been charged.
And we've got some people in the audience that represent that office, actually. And I think we're going to skip that last question, the regional question, so that we can let Jamie do a wrap-up and get to a broader conversation with the audience. Is that okay with you, Suzanne? Yeah. Now, we've given Jamie the toughest job, really. It's the cleanup, batting cleanup, and it's a question of whether or not what he sees as the interplay between IHL and human rights in the future, where we go from here. But I'd also ask that he address this conflation trend of IAC and NIAC in the future. Where do you see it going, Jamie? And feel free to kibitz on anything any of us have said prior to this.
Dick, thank you very much. I don't know how to prepare for this, actually. So I was thinking about it this morning when my 3-year-old daughter was asking me questions before she was going to crash, because it was always why. And every time I gave her an answer, it would be a why. And so I realized I would never satisfy her curiosity, but at least I sort of palm her off for a few minutes. So I'm going to try and do this now. And you don't look like my 3-year-old daughter, but the questions you raise are very much, they're very similar, why. And as you said, a wrap-up, I'll use that. It doesn't get better. Another expression I sort of remember this morning was I was at a conference in The Hague a few years ago, and the late Robert McNamara was speaking, and he was asked, how did you ever deal with the media who are always asking you complicated questions? And he said he wouldn't actually listen to the question. He would always answer the question the way he would have wanted it to be asked. And so he'd always push back. So I don't know how to answer this one. But I'll give you 4 questions rather than answers based on this sort of wrap-up. The first, I think, what I gather from this is ultimately what are we trying to do with the law? What are the aims of the law? And I think a number of the speakers mentioned that already in terms of protections for individuals, whether it's in armed conflict situations or whether it's in peacetime situations. Peacetime being most probably the human rights approach, and armed conflict situation being the IHL approach. At the same time, of course, we're trying to make sure that those using force, those detaining, the security apparatus, has the necessary flexibility to carry out their operations, be they law enforcement or use of force military-style armed conflict type setup. But for me, taking it from an IHL perspective, very much a protection angle. And that's what the law is trying to do, and in the 2 different strands. Then I decided to look at what has the law done so far over the past few decades. And I think you all mentioned that as well. It's a very much a reactive body of law, both the human rights component as well as the IHL component. The IHL component has, for the most part, reacted to, let's say, the realities of the Second World War, post-colonial period, etc., with the 4 Geneva Conventions and the additional protocols. There's been very little reaction, as we know, on the non-international armed conflict component, with AP2, 22 or so articles, and Common Article 3 being the only ones which refer to the non-international armed conflict situation. International armed conflict, for the most part, seems to cover most situations that we need to cater for, and it seems to be a dying trend of there being international armed conflicts in the traditional sense. So human rights, and I think you use the expression, has stepped in to be the gap filler, and international humanitarian law has recognized that. And you will find articles in the Geneva Conventions which turn to human rights law to say, this should not be interpreted in any way prejudicial to human rights standards, and you should refer to domestic law and human rights law, which is very much what IHL is about. It creates a framework body of law to allow for domestic law, state responsibility, implementation, domestic law, and human rights norms to apply in situations which are not covered by international humanitarian law. And then I thought, okay, I'm thinking like my daughter would think on this one, but why? Even though it could be a what or when. And thinking, okay, why do we have the confusion today? What is it that's making many individuals, right, like Jeff and others, article after article about this lex specialis, this complementarity, the morphing of the different bodies of law? And I think it's because we have, on the one hand, the confusion of what's happening in the field, the nature of the conflict, and I think you touched upon it already with the counterinsurgency nature of the threat. You mentioned it as well in terms of the continuum. When does a conflict start? When does it finish? Does it start again? Does it go from being an international armed conflict to a non-international armed conflict to a peace-sustaining situation, and then again to a non-international armed conflict? And that continuum creates quite a lot of confusion in terms of what law should be applied. And so we need clarity and certainty in that regard. The other area where you have certainly sort of shortcomings, confusion, has been created by the political reality of what we're dealing with today, in terms of the fact that people have tried to manipulate or undermine the law as it's known to justify certain means. We have extensive discussions, for instance, on the question of self-defense, right of self-defense, Article 51 of the UN Charter, and the blending of the ad bellum and in bello arguments, which again is adding to the extra dimension of confusion. So from that, I'm saying, okay, we need to take, there needs to be a certain amount of clarity and certainty in terms of the situations with which we're dealing, and in terms of the kind of law that we want to apply to those situations. That does not answer your question, and I don't think I can give you a perfect answer, but maybe on some of the themes that we need to look at specifically, rather than trying to say whether human rights law or IHL applies to the situation. As Laurie mentioned, maybe we need to look at aspects that we are concerned with in times of armed conflict or in quasi-armed conflict type situations, which are particularly relevant today. Detention, you mentioned, Rick, is one, I think, of the most important ones. Under what standards are we holding individuals? On what basis? Connected to what? You mentioned Guantanamo. I was in Guantanamo last week, just a few days after the executive order came out, and without breaching any confidentiality or confidential dialogue with the U.S. government, I know there's a few in this room, just to say that the detainees, like most of us, were somewhat confused by the executive order. What exactly does it mean? We know there's a standard, but is it a standard driven from an IHL standard? Presumably yes, because there's reference to law of war detention. But if you look at that standard in a non-international armed conflict situation, it's not that clear. That's AP2 and Common Article 3. That standard is driven by analogy to international armed conflict, AP1, and the 3rd and 4th Geneva Convention. Again, which approach are we taking there? Are we taking a GC3 approach or a GC4 approach? The ICRC tends to prefer a GC4 approach. We're looking at civilians who've been detained for security reasons. The executive order has taken a GC3 approach in terms of individuals being detained as unlawful combatants, more in a sort of POW style approach. So many of its procedures, but the standard, yeah, but exactly, that's the confusion. In terms of, we don't want to call them civilians on the one hand, and we don't want to call them combatants on the other, so they fall somewhere in between. And maybe there's truth in that. But again, it's up to us to try and figure out where the truth lies and what is the actual standard. Detention, targeting as well, is linked to, for me to the question of the battlefield, the scope of the battlefield. How far are we going to go? We had questions about Yemen earlier in the day. Are we, even though there's a use of military force, are we still applying the law of war paradigm or not? Hence my question, a little bit related to what you were saying earlier, Gary. When you say the US will apply through the DoD directive the laws of war, it goes back to what you were saying, then you have the collateral damage assessment, which becomes a bit of a head-scratcher. Are you going to make the same collateral damage assessment in what many individuals would argue is actually a law enforcement situation and not a law of war situation? Again, there is a need for clarity, both for the operators, who don't want to find themselves before an international jurisdiction which might not recognize the same approach as the US and other countries have, but also for those protected from the attacks. The last sort of one I sort of highlighted there is monitoring. Whose role is it to monitor the violations in these types of situations? The ICRC sees itself as a custodian of the Geneva Conventions, but it's a very specific role to ensure the respect of IHL. It's not a monitor in terms of a criminal entity. But now you have situations of the human rights sort of bodies of the UN, whether it's called the committee or the council, I can't remember anymore, but headed by Nathan Pillay, commissioner, we have situations where you have human rights bodies investigating war crime situations in contexts which are maybe a blend of both. And so you might have a strong influence of a human rights approach to assessing what's going on, when in actual fact it should be very much an IHL-centric type of an approach. And that could add to even further confusion in terms of accountability later in time. So, again, no answers here. But I think what we need to sort of address is actually to grapple with the harder questions now. Rather than saying, does IHL apply or does human rights apply to a particular situation, try and figure out what these situations are, once and foremost. And also, I think, realize that these situations are not what we know for the past 20, 30 years or so. It's a sort of, they're not new situations either. The Anglo-Boer War was exactly the same kind of idea. Transnational threats have been there, and non-international armed conflicts way predated international armed conflicts. We just needed to go back centuries. NIAC, confluence, transnational, customary law. Just to do a quick salesman job for the customary law study of the ICRC, which was not written by the ICRC as such, but by about 100 or so experts in a number of countries. There were 166 or 68 rules, of which all of them were deemed to be customary in nature in international armed conflicts, but the ICRC and the experts believed that actually about 160 or thereabouts would apply to non-international armed conflicts as well. So the actual qualification of the armed conflict seems to not be so important anymore in terms of the protections which are to be afforded to the individuals and to the rights of the warring parties in terms of what means and methods they can use. I hope that answers all the questions you've asked me.
Hadar asked us to look at Libya, so I'm going to give one more round, one chance for anybody here to really address the issue of Libya and the current conflict in Libya and what law applies in what way. So let's start at this end. Have you got a view of that?
Jamie raised, the human rights bodies, which is kind of related to the question you presented earlier, they do, at least with the regional bodies, they do have very different approaches to the application, or maybe very different is a little bit extreme, but they have different approaches to the application of IHL in human rights cases. So the Inter-American system has been much more flexible, right, and has at times, the Commission more than the court, but almost said that we're going to apply directly international humanitarian law, if not as an interpretive tool, whereas the European system has been a bit more hesitant and rarely, if ever, made reference to humanitarian law when dealing with human rights cases. But I think one of the things that we need to struggle with is the actual, conventions themselves are different. And so whereas in the Inter-American system, the definition of what arbitrary means is not defined explicitly. It gives the Inter-American Commission some room to sort of infuse the definition of arbitrary by looking at the context of our conflict, by infusing it with IHL norms. I think there's much less room in the European Convention. The definition of arbitrary is limited to the circumstances in Article 2 for the definition of the right to life, and then you would have to have a derogation of that Article 2 right to life, which hasn't really ever happened, to get into an application or a way in which you can import IHL into the human rights cases. So I think in some ways that sort of explains their hesitance to kind of full-on take ownership of IHL in their analyses. What they do is they sort of do the human rights analysis, looks like an IHL reasoning, but they sort of couch it in terms of human rights language.
Just two fingers. It's great. I'm not doing a Winston Churchill style either. But I agree with you. I think my point is more looking towards the UN bodies as such, and those investigations. We have the situation in Libya, for instance, right now, where you have the ICC has been seized with the matter, so they're going to take a criminal type of approach and look at the various consequences of anti-war crimes, genocide elements, and who knows, maybe aggression is going to be thrown up. But they'll also look, then you have the Human Rights Council has asked for, I think it's Sherry Baswin or something, a commission. So with those, how will they work together? Will one undermine the other? Will they come to the same conclusions? And I was speaking with the keynote speaker earlier. What if one concludes no war crimes and another concludes yes war crimes? Is it because of different approaches or different evidentiary standards? That, again, I think leads to maybe some uncertainty and clarity. Maybe I might be wrong on that one, but it's just something that adds to the confusion we have today.
Yeah, and I would just add that this is a unique situation because on the whole, the most part, the commissions usually predate the establishment or the referral of a situation to the court. So in Darfur, for instance, the commission outlined its findings, and one of its recommendations was referral by the UN Security Council to the court. In this case, they're happening simultaneously, and I think you're right that it creates a lot of potential, well, ambiguity, but also potential for conflict.
Is there anybody on the panel that that would like to talk to the manifestation of this confluence of IHL and human rights in the responsibility to protect and essentially humanitarian intervention in a case like Libya?
No. I think I'm in a minority in that I don't see our intervention in Libya as an R2P issue. I know R2P has been talked up, but I don't see it as a real live concept. We intercede where we find it in our national interest, and we fail to intercede when we don't find it in our national interest. And I find, and I know I'm in a minority, RP2 to merely be a conveniently mouthed principle that's not really observed.
Some would say that that this is the confluence of jus ad bellum and human rights law, and but it flies in the face of this Westphalian sovereignty system that we've created, where states are the masters of their own territory and everyone else be damned, at least in terms of applying your standards in my state. So it's a great example of the issue, but it's one that we're really going to have to see where it goes, because I was talking to a bunch of students about other possibilities for applying R2P. You know, what about could we have applied that approach in Chechnya during one of the two Russian suppressions of the Chechnyan rebellion? Is there a what's going to happen in the future with this concept, and is it going to be widely accepted by states? So it's a real thorny one. In this particular case, there's enough support from regional organizations like the Arab League and NATO and the Security Council to make it happen. But it may be a case of a one-off case. Okay. Anybody else want to attack that issue?
Well, just one comment I would have is I think the R2P aspect is the jus ad bellum aspect, and so it doesn't, as you said, so it's not impacting necessarily the application of LOAC in the conflict, except to the extent that it has an impact on whether it stays a non-international armed conflict or becomes an international armed conflict. And in that sense, the impact is on the status of the international forces who are intervening, because if they were considered peacekeepers, then they would have the status of civilians. If they're considered an intervening force, then they're combatants of some kind. And so that's where I see the linkage. But the purpose, I hate to conflate them in any way whatsoever, but I guess, and I would resist that. But I think it's informative in that way in how we view, like the 2 American pilots who crashed. What if they hadn't landed next to the farmhouse of a guy who was sympathetic to the rebels? What if they had landed at the opposite farmhouse, and now Gaddafi's forces got a hold of them, like the Dutch or the Dutch Marines who originally ended up in Libyan hands? How do we think about them? Are they equivalent to a peacekeeper, in which case they have certain protections? Are they equivalent to, a combatant?
I had one thought that I shared just before we started when this issue was raised, and I see it as an issue that has demonstrates the way in which the situation in Guantanamo is ever shifting based on the reality in the outside world, and that is we have one remaining client at Guantanamo, and he happens to be Libyan. He is one of 5, I think, who are still there. And in making arguments about his release, I don't think I can talk a great deal about this without sort of running afoul of our own limitations on talking about it extensively. But essentially, we made a case that his return to Libya would be a death warrant, that Gaddafi would kill him. He left Libya in circumstances in which he was a strong opponent of the government. And I think as a practical matter, his situation has changed markedly in terms of the ability, potentially, to sell his release to a friendly country in Europe that might be willing to take him, given the way that events have unfolded and the sort of reality that Libya and its situation has presented to the world in terms of the support for those who have rebelled against Gaddafi and the madness of his regime, if you will.
Be interesting whether or not we consider him a co-belligerent now of our own coalition forces rather than a enemy combatant on the other side. Let's open this up to the floor and entertain questions about NIAC and IAC, about the confluence of human rights law and the law of armed conflict. Come on, I know you've got them out there. Yeah, if you could.
It's possible to raise it. Whether I can raise it. Gary, I'm willing to man up to that. Mike Cole, with the British Army, but I'm speaking here personally. First of all, thank you. That was a brilliant couple of hours, and my head is just exploding with all sorts of questions. So, and actually, I stand up. I suppose Gary said he considered his answer for about 10 seconds. I'm not even sure I've considered my question for as long as that. So just a stream of consciousness, and I'll try and get some questions in there as I speak. Firstly, do you think, I suppose to Gary, if military forces use, I'll step back, we're told that the method and means of warfare is not unlimited, one of those sort of principles. But it's not necessarily limited to using kinetic force as a first option, which is maybe something Laurie sort of touched on. So if military forces decide to use as one of their methods and means of warfare practices and procedures that look rather like human rights style procedures, prosecutions, criminal prosecutions, etc., does that mean they're just using a method and means of warfare, or are they actually using human rights law? And should they be concerned about going down that route if then people are going to jump on it and say, well, clearly human rights law is now applying? It's sort of one of those you're damned if you do, you're damned if you don't sort of approaches. So sort of thoughts on that. I think this idea that lethal targeting is in armed conflict, the first resort is outdated now. I really do. I think targeting means all sorts of different things, and lethal is just one of them. And the idea it's a first resort, I think, really is outdated in most soldiers' minds. And to that extent, I don't think, yes, you get some ambiguous situations. But I really think we do our service personnel an injustice if we think that they can't work through some of these ambiguous situations. It's not black and white. It's not on or off. They have to consider all sorts of things, and they do on a daily basis. So, you know, the idea of a continuum of force or a continuum of methods and means of warfare is something that I think our service personnel use all the time. So we shouldn't be too worried about the fact that, you know, they have choices and they have options to apply in different circumstances. Something, Rick, you mentioned, and I've never really been, I haven't been particularly interested or concerned myself in obviously the American habeas corpus sort of applications, but you talked about, I think, one judgment talking about if there's an intent to deliberately get outside the jurisdiction. Do you think where, maybe as a method and means of warfare, we decide to hand over our detainees to another power, maybe to the state we're helping, we're Y, we're helping X, we hand them over, there is that could be that sort of intent, because we don't want to be caught up in exactly these sort of domestic issues. And would we fall foul of that sort of jurisdiction, or rather that sort of intent argument? There's one for Rick. For Dick, you mentioned about AP2 going to the Senate last week. I must have missed that in my lunch hour or something. Maybe if you could just talk about that, because I completely missed it. And yeah, that's about it. Stream of consciousness. Thank you, but really, thank you. That was a fantastic panel. Thank you.
Let me start with AP2, because I actually mentioned two facets of the presidential fact sheet that was issued on the 7th of March, the same day as the executive order. What he announced were two things that have been in works for a couple of years now, and it was just like an aside at the end of the fact sheet. So, but it's I think very important to recognize in this community and in this discussion, because first of all, he said that that the U.S. will treat as a legal obligation in international armed conflict, which are the terms of its provision, AP 1's Article 75, and expect that other nations would also provide those as the minimum protections in international armed conflict. That's it's a statement of opinio juris. I mean, it's as clear as any that I've seen in a long time. So that's the first crack in this. What do we do about AP1 question to come out of the U.S. government? And so that's why I think it's a momentous thing. Second thing is they said that they will request again. I mean, it's gone in a letter twice in the Reagan administrations and the Clinton administrations. AP1 has gone to the Senate saying, Senate, please ratify this. But this is really the third president that will say, and has already sent a letter signed by Secretary Clinton and Secretary Gates to the Senate asking that they ratify AP2. Additional Protocol 2 deals just with non-international armed conflicts. It helps us answer this question about what law applies in non-international armed conflicts, and gives us at least a bit more of illumination of what Common Article 3 means. Articles 4 through 6 of Additional Protocol 2 have every provision that's in Article 75 of Additional Protocol 1 and then some. So they describe a much more robust set of, well, I mean, it's not complete human rights law application, but it's at least a more detailed set of treatment of detainees and due process in criminal cases, which would apply to the military commissions and as well as any other penal sanction that's applied. So that was a big deal. Why don't I give Professor Wilson the first crack at the habeas question?
Well, it's a great question, the case that comes to mind immediately is a case that actually came from the very same judge I was talking about before, Judge Bates, here in the district court, a case called Abu Ali that had to do with the surrender to, I can't remember the country, I think it was Egypt, Saudi Arabia, and his concern was exactly the one you expressed, that the U.S. was, in a sense, manipulating its surrender of jurisdiction in order to be able to obtain information by a source that it wouldn't otherwise be able to get it by giving him to the Saudis. And of course that is a practice that we've endorsed, this practice of illegal rendition to other countries, or at least in the prior administration. That decision was pretty much in his favor, but the U.S. kind of trumped the entire issue by prosecuting him itself and bringing him here to the United States, or keeping him here in the United States to prosecute him for crimes. And he was prosecuted and convicted, if I remember correctly. That, to my mind, is the only case that raises that issue. And I think the fundamental problem is the one about sort of sovereignty and surrender of jurisdiction to another power. That is, once you give the person over to they leave your own authority, unlike Bagram, you have to deal with the issue about getting them back, if you will, from the country you've surrendered them to. And it's something like extradition, where, at least in my limited work in that field, you find that once you've surrendered somebody in extradition, the fact that they are within the territorial jurisdiction of the country to whom they're surrendered very rarely results in them being able to be returned to the place that they came from. There's no mulligans. You can't go back and say return him to the jurisdiction that should have had him in the first place and prosecute him appropriately there, or honor the human rights norms that you should have honored in the first place. I think the concern of the court, a conservative court, about manipulation was a legitimate one, and one that I think Judge Bates will. I'm guessing, although he didn't say why, that that's an issue he's going to look at. So, but it certainly leaves ambiguous this sort of terrain about the motives by which one ends up, and whether that's going to be the legal norm that we apply to whether or not habeas corpus extends extraterritorially, I think.
And with respect to Michaela v. Gates, I think there's 5 defendants involved in Michaela v. Gates, and one defendant came from Thailand. I mean, actually, petitioners. But the other 4 are from Pakistan. And one's an Afghan citizen that was detained in Pakistan. So probably the case that's most involved in this, quote, manipulation argument is the one from Thailand. The question is whether or not he was put in in Bagram, because it's the equivalent of Gitmo's original black hole, and that's kind of the controversy involved there.
Yeah. Mine's actually, this time it's a one finger. It's just a compliment on your question there to Rick about the whole circumvention of the obligations. What we would also look at from a sort of an IHL perspective, and it's also when you have an area of human rights kicking as well, is that, of course, we look at Common Article 1 of the Geneva Conventions in terms of ensuring the respect of IHL, which would also mean you have someone, you hand them over to another authority, you have to make sure that other authority respects IHL in that regard. Common Article 3, you could also talk about responsibility for ensuring humane treatment. It's not explicit, but you could interpret that to mean that you can't circumvent your obligations under Common Article 3 by handing over to another authority. And then this is where actually human rights and IHL work pretty well. You can tab on the whole non-refoulement component, which you talk about pre-departure. Before you hand over to another authority, you need to ensure there are no fears or well-founded fears that the individual will be ill-treated. That's how we sort of make sure you move away from the circumvention of those obligations under IHL.
That oftentimes is taken.
We have this whole distinction between law and policy. I think under IHL, the law is less clear as to what is a continuing obligation, but there certainly is a moral and humanitarian obligation to the extent possible, and that's why you will see a much bigger drive, especially in places in Afghanistan and Iraq these days, about post-transfer monitoring, and to ensure that you have post-transfer monitoring capacity, capabilities, but also that before you do the transfer, you do the necessary assessments. Diplomatic assurances are insufficient in our minds, and you also allow for, if you're in a particular country, capacity building, judicial capacity building, infrastructure, and you leave behind something which can actually function once the UK and US, for instance, have moved out, that the national authorities can properly man and oversee detention operations.
And this gets to the assurances question, which is a very deep discussion, but I'd commend you Ashley Deek's article on it that talks about the left and right limits of assurances and compares it to regional bodies' approach to the issue. Lori has something she wanted to say to Cole.
You raised a really good point about the infrequency of lethal targeting now, and how soldiers are automatically applying a continuum of force. So I just wanted to clarify a little bit that what I was talking about before raises, I think, the next layer of questions, which is that the application of a continuum of force, of choosing not to use lethal force, that's in essence an operational or a policy choice within the broader framework of what the law allows. It's an ROE question, it's an operational question, it's a not can I but should I. I can choose to target, but I'm going to choose not to. I think the question that comes into when we're talking about when law enforcement standards are appropriated in a NIAC or in any other situation versus law of war standards, this question of a continuum of when we look from one set of standards to the other is not a question of operational choice. It becomes a question of legal framework. So now what could happen, in essence, if this sort of continuum approach were to take hold, or if you take an after-the-fact analysis that's being used and you put it into place retrospectively, is that instead of it being an operational choice within a broader legal framework, it becomes a series of changing legal frameworks that bind how force is used or other means or methods or detention or treatment or something like that. And so that then, if you can imagine that, if a legal framework is changing, not just an operational choice or the ROE, but the actual legal framework begins to morph and slide and change, that does create much greater ambiguity, because it's no longer what is the right operational choice without the sort of, well, if I make X choice, am I violating the law? I may be violating ROE or something else, but you haven't stepped outside the boundaries of law. Now you're talking about constantly wondering where the legal boundaries are, which then gets much more confusing. So it's not so much a counterinsurgency policy question in that sense.
And that's really an important question, because it gets to the nature of customary international law too. And of course, as a legal advisor at the within a government, my advice is stick with the policy basis for these changes rather than establishing practice and doing it out of a sense of legal obligation, which will, of course, create customary international law. So we have the U.S. government has a very narrow view of what's customary international law that was provided publicly to the ICRC and to the Customary International Law Study. But that's why that point about Article 75 is a big deal, because we haven't said something's customary international law in a statement of opinio juris in a long time. Professor Solis, would you like to get to the either the legal the targeting as a first resort, or lethal force as a first resort question? Have you got anything to say on that? And
my recollection of the question was whether or not it was a method of warfare, that is to start employing human rights law, and I believe it is. And human rights, excuse me, yes. Yes, and I think it's beneficial. You know, I think that you in the audience are extremely lucky, as we are extremely lucky to be in an era where LOAC IHL is changing dramatically and quickly. We've seen such great shifts just in the last 8 years. Thank you, George Bush, you made my career. But we see changes we never could have dreamed of just 15 years ago. We see the merging of human rights law and IHL. And we see a merging of Common Article 2 and Common Article 3 armed conflicts. And I think that's to the good for the victims of armed conflict, which is what the Geneva Conventions are all about. And I think that DOD's initiative in 1998 to say that the law of war would apply no matter what the conflict status is all to the good, because that eliminates a lot of ambiguity, provides warfighters with some clarity, and most importantly, increases, I think, the protections that are received by the victims of armed conflict. And by now I've forgotten what the rest of your question was.
Do we have any other questions, sir? Yeah, great. Well, first of all, there's I talked about this a little bit before, and there's this mixture, and Jamie talked about it too, the mixture of jus ad bellum and jus in bello. And as I said, General Ham said, we're protecting civilians. Well, yes, that's the mission, that's the mandate. The UN Security Council resolution is the mandate. So that's what the military forces are doing. They're working in accordance with the mandate. Now, all necessary means is in UN language is very broad. So it's whatever's required, basically, to accomplish the mandate of protecting the civilians. But that's a very limited mandate in the sense of an end state. Okay? So what means can be employed in order to accomplish that mandate end state of protecting civilians is broad. The means are broad, but the end state is pretty narrow and kind of undefined. So if, I mean, theoretically, and, you know, this is just Dick Jackson speaking. In fact, the whole day it's just been Dick Jackson speaking. It's not the Department of the Army, DOD, or anybody else. And I'm not in on the targeting discussions, unlike my predecessor, Hayes Parks, in 1986, who was involved in writing the assassination memo that was regarding whether or not we would target Gaddafi in 1986. So the Army is not as relevant as it once was, I guess, is what I'm telling you. So the targeting decisions theoretically could include command and control nodes. I'm sure I heard that mentioned on the television the last couple of days. And the building, I'm just completely speculating here, the building that was in Gaddafi's compound, I wouldn't be surprised if that wasn't a C2 node, a command control communications node for the Libyan military. So a communications node, valid military objective, and it's certainly a valid military objective for the purpose of accomplishing the mandate of protecting civilians by establishing a no-fly zone. No-fly zone thing is a question of whether or not that's the mandate or protecting civilians is the mandate. And the Arab League has debated that recently too. Anybody else have anything to say about that question? Okay. We can certainly, many of us will hang around if you have any other burning questions. But I think what we've demonstrated through this series of questions is exactly what Gary said a few minutes ago, that there's a lot of flux in the law right now, but that's not necessarily a bad thing. There is definitely a confluence of IHL and human rights law. That's undeniable. There's intersection there. No matter how much the previous administration protesteth that human rights are not of any import here in international armed conflict, I think it's well demonstrated that they're important. They're important not because of their extraterritorial application as a treaty, but as a gap filler and as a means to apply the rule of law in these ambiguous situations. At least that's my view, and I think Jamie agrees with that too. It's a and the other thing is that I don't think that the IAC-NIAC, the International Armed Conflict, Non-International Armed Conflict conflation is a bad thing either, because what it does is provide our soldiers, sailors, airmen, and Marine a standard to apply no matter what angels dancing on the head of a pin are being argued in a given conflict. You know, I was the legal advisor in Panama to the POW camp. Okay, I was just some dumb major who'd never done that before, you know, so I pulled out my regulations and my FM 2710 that Gary has here, and I said, well, you know, what advice am I going to give to this camp commander in Panama? And the first question that they teach you at the Army JAG School is, you got to figure out which kind of conflict it is and which kind of person it is to determine what the law is. Okay, well, that's fine for an academic, but that really gives you problems, okay? What kind of conflict were we in Panama? You know, so I called Hayes Parks up at Department of the Army. I said, Hayes, what kind of conflict are we in? And a couple days before, Hayes had been providing advice to, you know, people up in the stratosphere about, you know, whether or not we were going to call it an international armed conflict or we were going to call it domestic conflict because Endara had been placed as the president of Panama in the hours before we invaded. Okay, so, and Endara said, oh, now that I'm the president, I invite you in to assist us. So there's all this discussion about, you know, jus ad bellum and what kind of conflict we're going to call it, and we weren't really sure what kind of conflict it was at that point in time. Well, that kind of conversation is repeated basically on a daily basis all over the world in whatever conflict we're involved in. We still haven't really said what kind of conflict we're in Afghanistan officially, you know. We had this question about when Iraq became a NIAC, you know. We never got to a decision on that within the U.S. government. Okay, so you've got all this confusion. The soldiers, sailor, airmen, and Marines have one standard to apply. It's the International Armed Conflict Standard. It's the 4 Geneva Conventions. It's the 1907 Hague Regulations that protect the victims of conflict, that provide extensive rights to those protected persons. And if they start with that standard, that's pretty good. It'll pretty much take care of most human rights concerns. And then when we have questions about specific standards in a specific instance, take detention for example, it's great for those soldiers, sailor, airmen, and Marines to be able to go to, and Helena Page from the ICRC has a great article on this detention standards issue. It's great to go to human rights and apply that by analogy in the law of armed conflict situation because there's gaps there. We have the discussion of whether Article 78 and Article 42 and 43 of the Fourth Convention apply, or the non-existent standards of Article 5 of GPW applies, of GC3. So when you got questions about specific standards, they can go to these other bodies of law to assist. So with that, the two topics for today, I think we've covered them, but it leaves a lot of questions. And so if you have any, and there's any answers we can provide down here, we'll hang around for a little bit afterwards. Hadar, would you like to close this thing?
Just use a microphone. I want to thank all of our panelists. This was, we knew this was going to be an interesting discussion. I think it was even more interesting than we had anticipated, and really very fruitful. Everyone's heads are spinning. It's been a very full day and a really interesting day. I'm hoping that afterwards we're going to talk a little bit about what we're going to do with this conversation, because I think it's important for it to be kind of memorialized in some way. I of course made a couple of notes so that I make sure to thank all of our speakers through the course of the day today. Again, to thank all of our judges who participated in the competition itself, to give a special vote of thanks to ASIL, to the Liber Society, and to Dick Jackson for all of his support, assistance, and partnership in all of this. And we have a special gift for you, Dick. We also have gifts for all of our speakers, and so we don't want you to leave without that. We know you all need another pen and a keychain. And a special thanks, of course, to Robert Clark and to Elizabeth Holland for their great work, for their great papers, and for their great presentations through the course of the morning today. So thank you again. And finally, a thank you to Maria Lokshin. Will you stand up, please, Maria? You're short. We want to thank her for her great work in really spearheading and coordinating the entire competition and today's conference. To our special events folks who have manned the table, staffed the table, excuse me, outside to our facilities office as well as our catering office. And so thank you all very, very much. We do not have the regular WCL post-conference reception outside because we really want to encourage all of you to go to the really fancy reception, which is taking place at the Grotius Lecture downtown at the Ritz-Carlton. Just to keep your head spinning a little bit more, a whole bunch of international law people down at the Ritz-Carlton and Professor Amartya Sen giving the keynote lecture at 4:30. So we hope that we will continue this conversation. We will continue this initiative in supporting and expanding the teaching of international humanitarian law in partnership with all of you. Thank you again for coming today.